Hey you guys, it is July 2nd, 2026. There was a Courtney Clenney status hearing this morning, and also I just saw it hit the docket, really it was filed yesterday, a motion in limine from Clenney's team saying, hey, state, if you introduce evidence that the victim's character, that Christian Obumseli's character, he was peaceful, to counteract our theory of a battered spouse defense, we have information about an arrest warrant against Christian Obumseli relating to animal abuse that we would ask to introduce if you open that door. So we're going to look at that motion in limine. The hearing this morning was just a quick status check. It was like 3-4 minutes long. I'll link it in the description if you want to watch the whole thing. But both parties are moving along with their depositions and said that they think that they're on track for an end of August trial date. They haven't set one yet, but they think they're on track. There's going to be a status check next week on the 9th, and then they want to do a motions hearing, which should be more substantive, at the end of July. So I'll let you know if that date gets set in stone and what that is. But without further ado, we got together a few days ago, and we looked at Clenney's response in opposition to the state's notice of intent to rely on evidence of prior bad things that relate to Courtney Clenney, things that would show she has a propensity to just be this violent person, evidence of other crimes, other arrests, other incidents, and other acts that don't necessarily rise to the level of arrests, police reports, things like that. I'll link the stream where we read this full motion in the description if you missed that one. And this filing today kind of goes hand in hand with this like chess move back and forth. Like, this is a claim of self-defense, a battered spouse syndrome defense, where look, I was in fear for my life with the way that I acted on April 3rd, 2022, when I fatally stabbed Christian Obumseli. And I'm going to call an expert witness to show you why that was the case. The state, in opposition to that, is going to want to put on evidence that, no, that's not how Christian Obumseli's character was. And the defense, in anticipation of that move, filed this motion in limine for pretrial determination regarding rebuttal evidence of the victim's peaceful character. So what do we got here? Hit that like button. Let's check it out. And of course, let me know your thoughts. So comes now the defendant, Courtney Clenney, who they're going with the first name, Courtney, by and through undersigned counsel and pursuant to 90.1041B, respectfully moves this court for an advanced determination regarding rebuttal evidence should the state introduce evidence of Christian Obumseli's character for peacefulness to 4041B2. Or otherwise introduce testimony, argument, or other evidence portraying Christian Obumseli as a peaceful, nonviolent, or non-aggressive individual, and states. So first off here, Courtney will assert that the death of Christian Obumseli was legally justified because she acted in self-defense and as a battered spouse. In doing so, the defense will present evidence that Obumseli was the aggressor. Accordingly, the state seeks an advanced determination regarding rebuttal evidence should the state elect to present evidence of Obumseli's peaceful character or otherwise portray him as possessing a character for peacefulness. And what might some of that character evidence be? Since the start of this prosecution, although the state has acknowledged that the relationship between Courtney and Obumseli, they're using his last name, was volatile, through its pleadings, arguments before this court, hearings, public statements, and overall litigation position, the state has consistently portrayed Courtney as the aggressor in the relationship, while portraying Obumseli as the victim of that aggression. Because the defense will present evidence that Obumseli was the aggressor, the defense reasonably anticipates that the state may elect to invoke Section 4041B2 of Florida statutes, which says that evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the aggressor, or other evidence that Obumseli possessed a character trait of peacefulness. And they're going to go through some Florida case law on opening the door. So, Florida courts recognize that the doctrine of opening the door permits the admission of otherwise inadmissible evidence where necessary to qualify, explain, or limit evidence previously admitted. And they cite Lawrence v. State. The concept of opening the door allows the admission of otherwise inadmissible testimony to qualify, explain, or limit testimony of evidence previously admitted. The concept of opening the door is based on considerations of fairness and the truth-seeking function of the trial. And that makes sense, right? If you're going to say this, but I have something that shows that, I should be able to present it. And then if I say that and you have something that says, well, wait a minute, that's not the full picture, then maybe I should be able to show this back. And that's how you get a presentation, a counter-presentation, a rebuttal, and so on back and forth. They say the doctrine exists to ensure that the jury is not left with an incomplete or misleading understanding of the evidence. Likewise, a party opens the door when it elicits testimony or advances factual assertions, creating a misleading impression that the opposing party is entitled to correct. They cite Robertson v. State. Whether evidence of Obumseli's peaceful character is introduced pursuant to Florida Statute Section 4041b2 or through some other evidentiary method, the issue remains the same. Whether the defense should be permitted to introduce rebuttal evidence when the state presents testimony, argument, or other evidence portraying Obumseli as possessing a character for peacefulness, gentleness, restraint, passivity, nonviolence, or otherwise suggesting that he lacked aggressive, abusive, cruel, or violent tendencies. So then we get into the thing itself. Obumseli arrest warrant for animal cruelty. Attached as Defendant's Exhibit A is the arrest warrant issued by the court in Travis County, Texas. And real quick, the footnote says that the Austin Police Department reports the affidavit in support of the arrest warrant and photographs documenting the condition in which Halo was discovered, Halo presumably the dog, will be provided to this honorable court and the Office of the State Attorney under separate cover, but are hereby incorporated into this motion. So I don't see this publicly filed anywhere, but TMZ obtained this information, so we're going to take a look at that. I'll warn you before we do. The evidence sought to be introduced, should the court determine that the door has been opened, is, and we've got a list here. Apartment staff discovered Obumseli's deceased dog confined inside a kennel located in a closet after the apartment had been abandoned. Investigators observed food inside the kennel, however, no water was present. The kennel contained feces surrounding the confined animal. A veterinary pathologist concluded the dog's most likely cause of death was dehydration secondary to water deprivation. Investigators determined that the dog had likely been deceased for approximately 5 to 7 days before being discovered. On November 12, 2020, Obumseli acknowledged that he knew law enforcement wanted to speak with him regarding the death of his dog, and that he was aware he was under investigation for animal cruelty. When interviewed, Obumseli provided vague, confusing, and conflicting accounts regarding his travel to and from Dallas and the events surrounding the dog's death. Investigators described his explanation as vague. Further, responding officers described his account as confusing and conflicting, and that Obumseli appeared to be more concerned about the police investigation as opposed to the death of Halo. The allegations supporting the arrest warrant describe conduct demonstrating an alleged disregard for the life and well-being of a defenseless animal. All right, so let's look over at what TMZ grabbed. All right, so we're going to look at the pictures. This is the TMZ article, so this would be a good time to step away for like 30 seconds, or don't look at the screen if you don't want to see the pictures. I don't think they are pleasant. They are not nice pictures. All right, so here we go. This is the condition in which the dog was found in the kennel. And then this was a picture presumably from an examination of Halo, of the dog. So there's that. We are back. No more pictures on the screen. They go on in this motion to say that scientific research and law enforcement literature have long recognized that serious acts of animal cruelty are inconsistent with a character trait of peacefulness and are frequently associated with interpersonal violence, including domestic violence. So they're trying to establish this is why it could be relevant to a case that involves theories of domestic violence, even though there's no animal involved in the alleged crimes in this case. And they cite here Catherine Robinson and Virginia Clausen, like the pickle, The Link Between Animal Cruelty and Human Violence, FBI Law Enforcement Bulletin, from August 10th, 2021. The FBI Law Enforcement Bulletin explains that animal cruelty is a predictor of current and future violence, including crimes of assault, rape, murder, arson, domestic violence, and sexual abuse of children. Should the state elect to introduce evidence portraying Obumseli as possessing a character for peacefulness, gentleness, restraint, passivity, nonviolence, or otherwise suggesting that he lacked aggressive, abusive, cruel, or violent tendencies, the defense would move to introduce rebuttal evidence so that the jury is not left with an incomplete or misleading impression of the evidence. And so the relief requested, the defense requests that before the state introduce reputation testimony, opinion testimony, witness testimony, argument, or other evidence concerning Obumseli's alleged peacefulness and all of that. Whether pursuant to 4041b2 or any other evidentiary rule or theory, the court conduct a hearing outside the presence of the jury to determine whether the defense may introduce rebuttal evidence. So before the state's able to introduce their evidence all willy-nilly, make a predetermination on if we'd be able to do this, almost like a warning. Right? I think this is a bit of a chess move here, if you ask me. Wherefore, defendant respectfully requests that the court enter an order requiring the state to approach the bench before introducing the above described evidence, conduct a hearing outside the presence of the jury regarding rebuttal evidence, and grant such other and further relief as the court deems just and proper. And there you go, submitted by Clenney's defense team. And they attached just the warrant. They didn't attach the photos. So That was, I saw the photos only through TMZ. I'm not sure if they got them from the court or contacted the Austin Police Department. But here is the arrest warrant and all of that information. And it's from the Austin Police Department. They're saying the offense date was November 2nd, 2020. It was for a Class A misdemeanor of cruelty to non-livestock animals. And the written complaint was prepared by Officer Ewa Wegner, filed before me. And it says, herein fail not, but of this writ make due return, showing how you've executed the same. Witness my official signature on this 30th day of December, 2020 at 8:45 a.m. And then signed off on by Barbara Garcia. So there we go. That is our July 2nd. I had to check the date real quick. A July 2nd update on the most recent happenings in the Courtney Clenney case. And remember, status update next week and possibly a motions hearing at the end of the month, which again should be like one of those longer hearings so we can get together and have more to talk about. So let me know what you think. Hope you are doing well and take care.